Good afternoon, guys. My name is Alina Shaltsova. I'm an immigration attorney from New York. In today's video, we will talk about removal orders. And can you fix your status in the United States if you already have a removal order or order of deportation? Thank you very much for watching. If this is your first time, welcome. I'm a practicing attorney from New York. I've been practicing for about 15 years. Immigration law, all aspects of it. And I help clients not only from New York, but from all 50 states and from overseas. If you need to reach me, please call at 917-885-2261 and let's start. Previous order of removal is a very vast, huge topic. Here I'm going to cover the basics. Why? Because otherwise there will be not enough time in the world for us to cover each and every aspect of the issue of the order of removal. Well, for starters, I'm going to tell you that orders of removals can be different depending on who issued them against you and when. Again, it can be an order of deportation, actually. It can be an order of expedited removal. It can be an order of removal by default because you did not show up for your immigration hearing, or it can be an order of removal so-called regular because you did not win your immigration case. Depending on when that order of removal was issued against you, also will determine what you can do about it and how you're going to go about it. Usually you have 90 days to file a motion to reopen to address an order of removal, but that deadline can be different. For example, if you are a VAWA applicant or if you're an asylum applicant and, for example, country conditions in your country recently changed, or for example, if your personal circumstances recently changed, so that it gives you new grounds to file for asylum. The time limitation and the number of motion limitations will not apply if you received order of removal because you didn't show up for your immigration hearing due to a lack of notice for that hearing. Extremely, extremely important to know that. Now we have to find out if you have a chance of receiving a green card. Now we need to see if you have a new basis to fix your situation. Usually it will be a petition by your spouse who's a US citizen or a child who's a US citizen and reached 21 years old, or perhaps it will be a VAWA self-petition. In certain situations, in order to get rid of the order of removal, you do not have to do anything. For example, if you receive a U visa petition, order of removal is cancelled by the operation of law. In certain situations, to file for adjustment of status, you do not have to file a motion to reopen because you are, or you were rather, an arriving alien, and USCIS is going to keep jurisdiction over your case, and you don't have to worry about the motion to reopen and order of removal. So imagine now, all these little aspects of your case must be known to the immigration attorney making a plan as to what they're going to do with your case. Extremely important. In most situations, a motion to reopen will have to be filed to fix the situation with the order of removal. Now you know that there is a limitation on time and number of motions to reopen, but there is one major exception to that limitation. That major exception is called sua sponte motion to reopen, when the court, immigration court, or Board of Immigration Appeals, using their own power, would try to help you out and reopen your case when you do not have statutory grounds for reopening, such as time limitation is against you or number of motions would be against you. So that sua sponte motion of reopen works, for example, if you received your order of removal long time ago and now you're married to a US citizen, provided that you can show how, if the motion is granted, you will be able to fix your status. It also works for the cases that have been tried to be reopened many times before, but were not for some reason. Usually, again, due to the missed deadlines or due to the fact that the person filed the motion to reopen and it was defective. Well, usually it's attorney's fault, but the client is going to suffer because of that. And let's say such a defective motion was filed on time, but it was denied due to this defect of some sort. So now there is a sua sponte ability to reopen your case. Very, very often you can use that. So finally, what's important is to see that if we file the motion to reopen and it works, will we be able to help the client? Will the client be admissible and qualify for that relief, that green card probably that they're looking for to get? And for that, we need to know all possible grounds that the client may be inadmissible for. Usually, those would be multiple entries to the United States that resulted in a permanent bar, claim of a U.S. citizenship, criminal convictions for which we cannot file for the waiver. There are some situations when we cannot file for the waiver and the person will be forever inadmissible. Potential misrepresentation or fraud or lack of good moral character if the application we're seeking to file would be based on discretion by USCIS or immigration courts. So all that information has to be gathered prior to us acting on our desire to reopen that old immigration case. What it means for you as a client is that if you are interested in trying to fix an old order of removal, what you need to do is to obtain first copies of your immigration history files through Freedom of Information Act requests, and if you had any criminal encounters, you have to get certificates of dispositions for each conviction, for each arrest that you had. And you also preferably should obtain minutes of guilty plea and minutes of sentencing. That information is going to help attorneys that you will be consulting with to determine whether or not they can help you. Well, thank you very much for watching. I hope this little video is useful if you do have an order of removal and thinking as to how to go about this. Do not forget to like and share this video, subscribe to my channel, and I hope to see you